Hi, it's Massachusetts OUI lawyer Mike DelSignore. Today's video I want to talk about what are your best options when charged with a first offense OUI. It's clear the best options are not guilty. You want to avoid an OUI conviction, so if you can take the case to trial and win, that's undoubtedly the best way you can resolve the case. Now, there might be steps to get to that point, so if you refuse a breath test, it's a subjective case, so you have a good chance of winning the case. There's nothing objective about it. It's going to depend on these field sobriety tests. These are often inaccurate tests. They're unreliable, and there's ways to challenge this evidence in court to say, well, it might have been enough for the officer to arrest you, but not enough for proof beyond a reasonable doubt. So fighting the case definitely is the best option. Sometimes if there's a breath test in the case, you might have to take the case to trial even with the breath test. I've had a case recently in a court where the breath test was not excluded at a motion hearing, but we excluded it on the day of trial. So in a breath test case, I think it's important to be patient. Let your attorney do all the motions, because a lot of times, somewhere along the process, they won't get that breath test in, and now they'll just be fighting the case on the observation. So breath test case is very winnable. Today I had a breath test excluded in court based on a failure to comply with the 15-minute observation period. So it's not uncommon for me to win a breath test case. The way I judge a breath test case is, what's the rest of the case look like? If the rest of the case is strong without the breath test, it's generally a good option, good decision to try to fight it, at least put it on for trial, see if they're going to get the test in. So winning your case, best option, not guilty verdict, and there's a lot of different ways to accomplish that. Next best option, if it's a strong case, be a continuance without a finding. It's technically not a conviction. You'll be on probation for a year, have to do an alcohol education program. It costs $13.50 now. You'll pay $600 to the court and eventually $1,000 to the registry. So those are really the basic two options for OUIs in Massachusetts. If you're in some other courts, there's a chance for the OUI to be amended to negligent operation, but that's very few courts like Nantucket, Martha's Vineyard, Western Mass courts, possibly Falmouth or courts on the Cape, but for the most part, there's not negotiation. If you're in Bristol County, they don't negotiate. Norfolk County, they're not negotiating an OUI. Worcester County, Middlesex, Suffolk County, Essex County. It's only those handful of courts where potentially you can get the charge reduced to negligent operation. So for the most part, your choices are fight the case, go to trial, or accept the continuance without a finding. Now, what happens if you lose after trial? Generally, you're going to get basically the same disposition on a first OUI. It would be a guilty instead of a quaff. For many people, the difference between a quaff and a guilty is not a major factor. You can seal a guilty after 3 years. You can seal a quaff a little earlier, potentially 2 years with an early sealing, but a quaff seals after 3 years as well. So keep in mind, it's a misdemeanor offense. These are charges where generally you're not going to suffer any penalty for going to trial. So your best options for first offense OUI is strongly consider fighting the case. I have a different way of I'm going to look at the case differently than other attorneys. I've been doing this for 20 years. It's pretty much all I do. I know each court very well. I've been going to courts throughout Massachusetts for a very long time. So I'll give you a different insight that you may not get anywhere else, and I'll give you my honest opinion of the case, tell you what I think your chances of winning the case. And a lot of times it's going to depend on what the video looks like. There's video evidence that usually takes between 60 and 90 days to get. So right after the arraignment, you're not going to have all of the evidence, but you'll have a good chunk of it to start deciding how best to handle this case and whether to take it to trial or to try to seek a resolution. My name is Mike DelSignore, Massachusetts OUI lawyer. Call, text me anytime at 781-686-5924.